Hello, everyone. This is Eric Nussbaum, and in just a moment here, we will be starting the presentation. I'd like to ask you, if possible, um, since there's a lot of names I don't know attending this today, if you could go ahead and put your name, well, your name will show up, but at least what district you're from, that would be great. And then we'll get started here in just a minute. So just to make sure, can folks hear me all right? Um, Someone could type in the chat box to make sure you hear me. That would be great. Great. That's good. All right. My name is Eric Nussbaum. As I said, there's some names here I don't know, which is great. It's a little bit smaller group than last week, but I expected that. So there'll be plenty of opportunities for questions. To give a little background about myself, I've been with the Department of Agriculture for about 15 years now. And I started out actually at the SWCD Soil and Water Conservation District as their district manager for 7 or 8 years back in the late 90s, early 2000s. Then I moved over to ODA, was a water quality specialist for about 5 or 6 years, and for about 10 years have been doing this job now. And my job at ODA is to put on trainings like this and to provide general operational assistance to the districts, trainings for the board, helping out managers, helping out chairs, and things like that. So the few housekeeping things here. Please keep your microphone muted unless you're going to ask a question, and it's fine to do it verbally or the chat box. Chat box works a little better because I can see that, so I kind of glance off to the side. It's on another screen. I am recording this session so that you or anyone else, one of your board members, can take a look at it in the future. It's going to be on the ODA website. I have the link for that at the end of this presentation. It will be up there in a few days. Also on our website under the training tab, SWCD tab, and then the training tab are some handouts that go along with this session. So feel free to go there and get them. And then one important thing is this only scratches the surface of important topics that we will be taking a look at. They are deeper dives that I've been doing. I can come and do it for your board. You can look at recordings and the presentations. But this is just to get you just a little bit of information, mostly to make you think about when you might need to take a look and ask questions of your manager or of myself or someone else who's been around a while. These are some really important topics. And then, as I said, the reference materials and everything is on your the website, and I hope you will go there and get it. I'm going to take a second here and pull something out. All right. So what I'm going to cover today for you. Oh, and Andrea, thank you for putting Umatilla. I would love to hear where some of you other folks are from, because I am. There are some names up there. Like I said, I'm not sure. And you can put those into the chat box, and that just works great. So I'm going to go over a little bit about who you are as a soil and water conservation district, a little bit about how the Department of Agriculture and the SWCD program interrelate. I'm going to then go through what authorities you have as a board member and what your powers are as a board of directors. Briefly, just so you have an idea of how you receive a grant from us every year, or actually from the Oregon Watershed Enhancement Board. But we manage that grant for them, and that's a general district capacity grant. I'm going to talk a little bit about that so you understand that. And then the three most important things I like to go over with new directors, and a refresher for directors who have been around, is I call them the big three: the public meeting law, the public records law, and ethics, because these are legal things that as an elected official are really important for you to know about. So Oregon Revised Statutes is laws enacted by the legislature. And you might hear the term Oregon Administrative Rule, OARs. Those are done by state agencies that usually are used to enact statutes. Important thing to know about both rules and statutes is they both have the same authority of law. Most of the laws related to SWCDs are in Oregon Revised Statutes 568. And so I'm going to go over a little bit about what's in ORS 568, just briefly. I have a whole folder here. If you're a brand new director, just elected or appointed in the last year, you should have gotten one of these folders in the mail, which has a whole bunch of the Oregon Revised Statutes and a welcome packet and some information on ethics and some fact sheets on a lot of different things. If you did not receive one of these and you would like one, send me an email and I will make sure that you get one. They're very informative. If you're an existing director and you would like one, I'm glad to send one to you too. All that information is also available on our website. So Oregon Revised Statute 568, there's four important things that I just want to point out amongst all the different things. Is the what the policy of the legislature is, which is essentially why you exist. The general powers of the board of directors, the 5 basic legal requirements, and bond and tax levying authority. I would say the general powers of the board of directors is a really important one to take a look at when you can. This tells you what you can and can't do as a board and as a district. So who you are, the policy. This is, I'm going to read it out. You can read it there along with me. If we were all together in a real meeting room, I would pass this out for you. But I think it's important for you to understand the basis for why SWCDs exist. We have, many of you know the myth about the Dust Bowl days and NRCS, when it used to be the Soil Conservation Service, and SWCDs being the local partners to try to make sure that didn't happen again. And that is all really true. That's our SWCD creation myth. But there is actually in law why SWCDs exist. So if you look at the policy, it says, in the recognition of the ever-increasing demands on the renewable natural resources of the state and of the need to conserve, protect, and develop such resources, it is hereby declared to be the policy of the Legislative Assembly to provide for the conservation of the renewable natural resources of the state and thereby to conserve and develop natural resources, control and prevent soil erosion, control floods, conserve and develop water resources and water quality. And then actually it goes on and on and on, but along the same vein. So that part tells you what the policy of the legislature is. And then the important part is section 2. It is further the policy of the Legislative Assembly to authorize soil and water conservation districts to participate in effectuating the policy set forth in subsection 1 in this section. And then it goes a little bit further. So I think it's important for district directors to know, and the staff also to know, that there's actually this legal background about why you exist, and that is to effectuate this policy of the legislature to conserve, protect, and develop the natural resources of the state. The other one is 568, 550. Sometimes when I look through this thing, I feel it's like the SWCD hymnal. And the 550 talks about the general powers of the board of directors. What's important about this is the general powers of the board of directors is that by law, special districts, and you are a special district, kind of like a fire district and a park and rec district, they're kind of classified as special districts. You're only authorized to do what the legislature has authorized you to do. And so 550 lists all the different things you can do. And that is all the basic things that you know about. But there's also some very interesting things in here. where you're allowed to borrow money and you're allowed to mortgage property. You're allowed to issue obligation bonds. You're allowed to do scientific research. You're allowed to own property. You're allowed to sue and be sued. There's a whole list of things you can do in here. However, if it's not in here, you're not allowed to do it. And you may think that, well, that would never come up, but it does come up occasionally where we've had to go back to statute, and some districts who have had some really great ideas about what they want to do just couldn't do it because they weren't authorized to do it. So if you ever come up with some great new idea about something you want to do, it would behoove you to have your staff or yourself or come to us and take a look at the statute 568-550, and then make sure that you actually are authorized to do what you would like to do, because unfortunately sometimes you're not. All right, a little bit about the Oregon Department of Agriculture. This is already a little out of date. Things have changed a little bit, but it's basically it. But this is the latest one that we've had available on our website. So this just shows a little bit about how ODA is set up, just so you get a general sense of it. And the important part is the natural resource program there in almost the middle. And that's the area where both the Agriculture Water Quality Program is, we'll talk about in a minute, and the Soil and Water Conservation District Program. Also in there, some of you might be familiar with the confined animal feeding operations. And then over in the plant protection is the noxious weed program, which does the weed grants, and some of you might be familiar with that. And other you might be familiar with some of the others. If some of you have some big agricultural operations, you might have worked with the Commodities Commission or Ag and Development Marketing, and in some districts, actually do the farm to school also. So the Natural Resource Program area has three basic areas, and it's led by Stephanie Page. Back when I managed this SIUSLA SWCD, Stephanie Page was my water quality specialist, and she urged me to actually apply to ODA years ago. And then it's divided into pesticides, the capital and fertilizer, and in the water quality and soil and water conservation district program. And our manager is Margan Allen. Some of you may have talked to her already, some may not. Within the SWCD program, we're very, very small. There is only Sandy Hyatt, who is the grant administration officer, and then myself, the operations specialist, and that's it. The SWCC, that stands for Soil and Water Conservation Commission. The Soil and Water Conservation Commission is an advisory body to ODA that advises us on policy for soil and water conservation districts. Barbara Boyer, who is the chair of the Yamhill SWCD, is also the chair of the SWCC, and she also has a seat on the Board of Agriculture. So she's a very busy person. So the SWCD program, we both have services and we actually have some legal oversight over Soil and Water Conservation District. So our services are the SWCD Capacity or Support Grant Management. Your staff mostly deals with that. That's the grant that allows you to both keep your doors open, the operation side of it, and then you might hear about this scope of work and the focus area, the other side of that grant, which is to do work on the ground and work with landowners. Sandy is also the coordinator for director elections. You may, especially if you're a new director, have talked to her, but she coordinates a very big task every 2 years of putting together the director elections. And then myself, I do the technical assistance, I call it operational technical assistance. Fortunately, I haven't done on-site now for a year or almost a year. Now it's all by this method, Zoom. On the phone, I'm on the phone a lot with managers and chairs. I put on the trainings. I'd love to do them in person, and so when we get back into being able to do that, I love to come out to the different boards around the state. I enjoy nothing better than having to spend all day driving to Burns or Ontario or Pendleton or Redmond or any of those places. I just love going there. And then I do some facilitation often when there's some needs to be facilitation between different parties. I will do that too. And then we have some legal oversight that is in the 568. The main ones are that we have to review your annual work plan and long-range business plans. That's part of our legal oversight. That is why every year when you apply or renew your district capacity grant, you send us the annual work plan and we double check and make sure your long-range business plan is up to date. We also legally receive your annual report and your financial reports. And then if you actually are having any boundary changes, mergers with another district, that happens really rarely. We had a big wave of those in the 60s and 70s, but not so much anymore. We hold those public hearings. There's also some more obscure oversight that we have that we tend not to use because it doesn't come up, but there are some other types of oversight. But these are the basic ones that we take a look at. And this is why we ask for these things from you and on an annual basis. Any questions so far? Doing good? All right. So I'm going to spend just like 2 or 3 minutes talking about the water quality program and how that relates to soil and water conservation districts. There has been an in-depth session on Monday, but there'll be another one on Thursday at 10 a.m. Ellen Hammond did it. It was great. It's actually one of the best attended sessions we had. And she will go through all this in detail. But essentially, the Ag Water Quality Program is based around the Agricultural Water Quality Management Act. For those of you involved with forestry at all, you know about the Forest Practices Act. Well, this is kind of the mirror image of that for the agricultural community. The way that it was set up was that in order for Oregon to meet their total maximum daily loads for polluted streams, there has to be some ag water quality plans to meet the Ag Water Quality Management Act. Unlike the Forest Practices Act, which is essentially practices across the whole west side and across the whole east side, the legislature and ODA worked to make sure that there was local control over rules to regulate water quality for non-point source pollution. They set up through law local management agencies, which are SWCDs, and local advisory committees, which help advise ODA to write your local water quality rules and the water quality plans. So that was how the water quality program started working with SWCDs, is they help set up these local advisory committees and help write the local rules. We did that through the water quality staff. Once those were set up, we needed to implement the water quality plans. And so the legislature gave money for these district capacity grants, which were for folks the districts to go out and help the agricultural community meet the ag water quality rules. The district capacity grant has evolved somewhat as OWEB came about, and the legislature no longer gave money to ODA to give districts. The money now comes from OWEB, though we do manage the grant. But in essence, these capacity grants have stayed the same, where they're to help the districts with helping the landowners meet the water quality rules and meet the water quality plans and improve water quality. And the capacity grant, as I said before, is split into some money for district operations to keep your doors open, and then the rest of it is for the scope of work, where you tell us how you're going to spend your time and resources and the money to go out and help the local landowners. The focus areas are, areas, as some of you know, which are, we ask that you pick an area to focus your work in. And then we have the strategic implementation areas, which is where the Department of Agriculture is going out and taking a look at some certain areas to try to see compliance with the ag water quality rules, and the district helps the landowners come into compliance if there's any issues. That's the very short version of the water quality program. If you want a whole 35, 45 minutes about it, tune in on Thursday morning. Any questions so far? Okay. So what are your responsibilities as a district board member? I will say that your most important responsibility is a fiduciary responsibility. Your biggest responsibility is making sure that the public's money and the grants, whether they come from OWEB or other sources, is public money before you actually get it, and certainly when you get it, any money in your possession is public money, and you're holding it in the public trust. So your fiduciary responsibility is make sure that money is spent appropriately. You do it through budgets and financial reports, and some districts actually approve all expenses. Other ones have other ways of doing that. But that is your number one responsibility. You also have the responsibility of oversight of your manager and perhaps your staff, depending on how your employee relationship is set up. And we're going to talk about that in a moment. And then you should actually approve and monitor your annual work plan to make sure that your district staff is doing the work that you would like them to do. And then you also are your public contracting board, and you are responsible for public contracting. And that's a big piece about fiduciary responsibility too, is making sure that when you do contracting, the public's money is spent well. Also, you should be developing and monitoring your long-range strategic plan so you know where the district is going too far into the future. And then finally, you represent the people that voted for you and what their needs are and what the landowners' needs are, or in the urban areas, what the urban areas are, especially for taxing districts that receive money in the urban area. That's their money that you're spending, and so you should represent them. These are the same kind of things that you would expect out of any public body, whether that be the county commissioners or court, the state legislature, your local fire district, your park and rec district. All of these things are common denominators for district boards and what your responsibilities are and what the public expects of you. Just hold on a second. I need a little sip of water here. I'm getting dry mouth. So I like to joke that for all of you that decided to become a board member and get elected, for all the great powers and authority you have, I hate to tell you that as an individual board member, you actually have no power and no authority. The way that districts work and all elected governing bodies work is that it's a collective power that has authority. As individuals, you have no authority, you have no power. What the board does, though, is that the board can give some specific authority or power to act on behalf of the board through board action. So through a resolution or a motion, policy, job description that's been passed, you can grant power to individual board members. And it has to be recorded in the minutes. So some of those examples are if the board supervises any staff directly, or someone is responsible for supervising your manager. Obligation to district funds, for those of you who have dealt with having to go down to the bank and sign the signature cards, the bank will want to see your minutes where you were approved to sign checks. And that has to do with the fact that that power has to be granted to you and in the minutes. And that's why the bank will want to see your actual minutes where it was recorded. If you're going to serve as a district spokesperson for public presentations, go to a public hearing and speak on behalf of the board, not as a private citizen, but on behalf of the board, you need board approval to speak on behalf of the board. You can't just go to a public hearing or a meeting, even a watershed council meeting, and say, well, I'm from XYZ district, and I'm here to say. You can't do that without the permission of your fellow board members. Some district board members manage projects at the SWCD. I think all our board members had some pet projects that they did, very interesting ones, and they managed projects. But if they were doing that on behalf of the district, they had to get permission in the minutes. And then even signing documents. If you have documents, those should be signed. So one of those things that I say is really important, and you can check with your district manager, is to see if you have job descriptions for all the board positions. One for your chair, vice chair, secretary, treasurer, and you're just run-of-the-mill board member. if you have job descriptions, then when that job description was passed by the board, those duties follow along in the job description. So for instance, if you've authorized the chair to supervise your staff, then, and it's in the job description, then you're all set. But if you sat and authorized Jane to, as chair, to go and manage the manager staff, supervise them, and then Jane is replaced by John, well, then the board has to go through the whole motion of going and approving John to manage or supervise the manager or staff. And the same with anything else. If they're authorized to speak on behalf of the district or sign documents on behalf of the district, if you change chair and you don't have a policy about what the chair is authorized to do, then you actually have to authorize an individual person again and again and again. So I am a big proponent of job descriptions for the various officers of the board and actually just regular directors, which shows what kind of things the directors are able to do. And if you want example policies, I actually have those, or job descriptions for the chairs. So all you have to do is ask. And I'm glad to send them out to your district. So just briefly, I want to touch about a relationship to the employees. Because one of the most common complaints I get sometimes from staff, especially in small districts, is I have 7 bosses and they all come to me and they all want me to do something for them, or they're directing where I should go and what I should do. And that should not be the case. No one should have 7 bosses or even 5 bosses or even probably more than 2 bosses. Best to have only 1. So I encourage you to check in with your fellow board members if you're brand new and see what kind of supervision of employees you have. If you're a larger district, you'll probably have a manager and someone from the board or the whole board supervises the manager, and then everyone else is supervised by the manager. And there shouldn't be any direction or quote supervision of, by any other name given to the rest of the staff. Sometimes an individual board member is appointed. At the SWCD, the board appointed our treasurer because he worked down the street and he would come in every week anyway to sign checks. And so he was the great person to come in and sign our timesheets, to approve vacation, to tell us when we weren't doing our job right or not. So that worked really perfect. Every now and again, you find that there's a personnel committee that directs the employees. That's a little, I think, challenging. I think there should be an individual board member or the manager system. That doesn't mean that the board members can't communicate with the employees, though there is at least one district where the manager has asked the board members to go through the manager just because there were some challenges going on. But generally speaking, board members, as long as they're not taking the employees too much time, could maybe get a little information from them or make some suggestions like, hey, I was down at Charlie's place and I think he could probably use some help. As long as that board member is not directing the staff person to go to Charlie's, but just informing them that Charlie might need some help, that's totally fine. So there's a little bit difference between providing and requesting information versus supervision. Any questions about that? All right, general question about liability. I'm not a lawyer, so you need to check with your carrier, but generally speaking, the board as a whole is covered by your liability insurance. However, if there's any willful neglect or dereliction of duty, that removes the individual protections, and there could be, and possibly your liability insurance coverage. There are some instances where you do have personal liability no matter what. The main ones being ethics and executive session, and we're going to talk about that. But generally speaking, if something happens, you have that corporate shield, and individual board members are folded into lawsuits against the district. So, but make sure that you don't have any willful neglect or dereliction of duty. And I do see that sometimes where board members just ignore certain laws knowingly, and I cringe about that. All right, I talked briefly about this before, so I don't think I'm going to go through this again. These are your 5 basic legal requirements, the 5 basic things that you have to do according to ORS 568. You should get to know your annual work plan and long range plan if you haven't voted on them yet. Usually those are looked at and voted on in the late spring before the end of the fiscal year. You do have to give an annual meeting. Interestingly, it's not your annual meeting. By law, it's called the annual meeting of the landowners of the district. You just put it together for them. They may or may not show up, but it is an annual meeting of the landowners of the district, and it has to be noticed in a very specific way. And at that annual meeting of the landowners, you have to give your annual report and your annual financial report. Present them is what they say. So you have to have your annual report and your annual financial report, which is your audit, done by the end before you do your annual meeting. So those are the 5 basic legal requirements, and these things that we actually track at ODA to make sure that you're staying legal in this area. Of course, there's a whole lot of other legal requirements as a district and especially as an employer, as you know. There's all the OSHA and employment department stuff and all the sorts of laws related to being essentially a business with employees. But these are the ones related specifically to SWCDs. A little bit about the capacity grant due dates, just so you're kind of aware of those due dates. You do quarterly reports right now, which is a financial piece that OWEB looks at, and then we look at your task reporting. There's always an end of the year report, and the grants actually are 2-year grants. Your financial review or audit is due to the Secretary of State and us at the end of the calendar year. That's for the previous fiscal year. Remember, in case some of you don't know, fiscal years go July 1st to June 30th. Hopefully you all know that. We haven't, the annual report is due to us. And then, as I said, the annual meeting is no set time because you actually have to wait until your financial review or audit is done and your annual report is done so you can present them at the meeting. But it probably should be done by June 30th of every year for the previous fiscal year. All right, so that is my presentation about kind of who you are, some of the important things about who you are and the operations of the district and ODA and how we relate to you. And then I'm going to go into the public meeting records and ethics. Before I do that, any questions about any of these things at all? I'm just going to wait a second and see if you type anything in there. All right. No questions. That could be good or bad. I have discovered that definitely by doing them this way, I don't get many questions. Definitely get more questions when it's done in person. All right, so we're going to tackle public meeting law first. So this is just skimming the public meeting law. I did do a deeper one, and you can get the recording of that and the slide presentation of that on our website. So just skimming the surface so you understand about public meetings. So essentially, a public meeting is when a quorum of the board gets together, or a quorum of any of your committees or task force that you put together get together. There is some of these caveats in there, like, a quorum is required to make a decision. If you're deliberating to make a decision or deliberating toward a decision, that's part of what a public meeting is. But essentially, you get the idea that a public meeting is when you get together and you start talking about district business. Because when you talk about district business, it's kind of hard to say you're not deliberating toward a decision because you're trying to figure things out. So the public has the right to attend any public meeting. And we're going to talk about giving notice to those meetings because the public has to know you're having a meeting in order for them to attend, because it is their right to attend. Just to get out of the way, the right to attend a public meeting does not include the right to participate. It is a myth that you have to allow the public to give public comment. There are some cases in public hearings that you do have to allow them to do that, but generally speaking, they get to come to the meetings, but you do not have to give them public comment. I will say, though, that I think public comment is great public policy, and so I do encourage it. But if you're running into problems, you're running out of time, you have a disorderly crowd, you can just not have public comment. So one of the big questions, as always, is, well, you know, we're going to have this committee, and you know, we're a 7-member board, so we're just going to put 3 board members on it. And that way we don't have to have public meeting law. We don't have to notice the meeting like we're going to talk about. You know, we don't have to take minutes. We don't have to do this. Unfortunately, any committee or advisory board or task force, if it's appointed by the board of directors, it becomes its own, in essence, its own board. So if you just say, I'm going to put 3 board members on that committee, well, now you have a 3-member board. And that 3-member board, if 2 of them get together, you have a quorum, and therefore you have a public meeting. So please understand that it doesn't matter who you put on these committees, board members, members of the public. Some committees might have even no board members. They become, in essence, their own boards and have to follow the same laws. As long as they're going to be making recommendations to the board or making decisions on behalf of the board. And, you know, if they're only providing information, that's okay. But if they're providing information that's going to lead to a decision of the board, well, that's actually public meetings too. So please understand, it doesn't matter who is on the committee. If it's appointed by the board, it becomes its own little mini board and has to follow the same rules. So if you get a quorum of this group together, no matter who that quorum is, they have to follow these same laws. Okay. All right. Well, what is a quorum? Oregon defines quorum as a majority, and a majority constitute quorum. Sounds funny, but basically it means it's a majority of the board positions, whether or not they are filled. So this is important. If you have a 7-member board, 7 positions, a quorum is always going to be 4 people. It doesn't matter if you have vacancies, it's always going to be 4 people. Additionally, by law, it says that a majority vote is a vote of all of those positions, not who's present, not the positions filled, but of all of those positions. So to have an affirmative vote for a 5-member board, you need 3 yay votes in every and all circumstances. It doesn't matter if there's 3 people there or 5 people there. For a 7-member board, you always need 4 yay votes. It doesn't matter if there's 4 people there, 5, 6, or 7. It doesn't matter if you only have 4 positions filled. You need 4 yay votes. And I got this question, abstentions are not yay votes. They're essentially nay votes. So you can't have, say, 4 people at a meeting and have a 7-member board, but only 4 at the meeting, and have 3 yays and 1 abstention. That is not pass any motion. So I can't, I've seen this happen where some folks think that abstentions don't count or unfilled positions don't count. They do count. So if there's one thing to take away from this, is that part there, that you need 3 folks at a meeting to have a meeting if it's a 5-member board, and 3 yay votes to pass anything. And if you have a 7-member board, you need 4 folks there and you need 4 yay votes to pass anything. So the next part about public meeting is that they have to be properly noticed. If they are not properly noticed, they're a violation of public meeting law. And that's because then the public doesn't know you're meeting and you're kind of meeting in secret. So the requirements of a meeting notice is, well, what time are you meeting and where it is, and then what you're going to talk about. The public gets to know what you're going to talk about. It doesn't have to be detailed, but generally what you're speaking about. And you have to give enough advance notice that people can reasonably find out and get there. There's no set time for a regular meeting. The Attorney General says should be like 2 weeks. I always say if SWCDs can do it 1 week ahead of time, that is great. Special and emergency meetings have their own noticing requirements. I'm not going to go into detail here, but they're different and they're shorter. And if anyone has asked you to be noticed of your meetings, if they've asked you in writing, email, or a written letter, you have to let them know when your meetings are happening in the form that they request. If they want a photocopied agenda, public notice mailed to them, they get it snail mailed. If they like it emailed, they can get it emailed to them. But if they have asked to be noticed of your meetings, you have to notify them of the meetings. If you're going to have an executive session, and we're going to talk about executive session here in a moment, you actually have to ensure that that executive session is stated and what the purpose is and the statute related to it is in your notice. And I had a whole session on executive session. I'm doing another one. I believe it's tomorrow at 4 p.m. No, tomorrow maybe at 6 p.m. It's written on another slide here. But it's very important to get executive session right because that's a violation of the law and actually has pretty severe penalties if you violate executive session law. And we'll talk about that in a moment. Where do you post notices? The only place that really people say the Attorney General and the courts have said is adequate is to let your local media know, let your local newspaper know. They do not have to publish it. You do not have to have them publish it, but you do have to let the local media know. And then that satisfies your meeting notice requirement. Other places that you can do it is notice boards, your website, Facebook, but case law right now says that your website or Facebook or posting on bulletin boards is not adequate in itself. Though I do take that back. They say if there is no newspaper or general circulation where you live in your county or your district, then you can go use notice boards in lieu of the fact that there's no local newspaper or general circulation. But just about everywhere has some newspaper. Executive session law. So again, I'm just going to go through this briefly, but it is important. An executive session is when you close the meeting to certain persons for certain sensitive matters. It's important to know that those matters that you're allowed to talk about are very, very limited. And they are very specific, and they each have their own very specific statute that you have to announce before you go into executive session. Some of the common ones I have down there are discuss employment issues, discipline issues, and performance evaluations, or exempt public records, or talking to your lawyer. Those are the ones that districts mostly use. There are other ones, but honestly, there's only about 12 of them in general, and they're very, very specific because you can only go in executive session for specific reasons. When you go in executive session, you can allow anyone to be in that executive session with you. It is your choice. I've been to meetings where no one has left. They've had staff people stay. They've had members of the public stay. But people can't talk about it. That's the reason for executive session. Other times I've seen everyone leave, or they've asked particular people to stay. Sometimes when they're looking at disciplinary issues or complaints against an employee or a board member, they'll have that employee or board member stay. So if you're going to hold the executive session, the chair has to announce the statutory authority for the executive session before they go into it. And there's a whole script for it. It's I have those scripts under the executive session training module. They're in the district guidebook. Your manager should have one. We try to make sure that you all have these specific scripts about how to do that. The news media has to be allowed to attend. And they are barred from disclosing what was discussed unless you stray off topic. Their job is to make sure that you do not stray from those very specific items that you are allowed to talk about. And if you stray from those, one, you're violating executive session law and make yourself liable to a fine, but the news media gets to report on what you talked about. You have to have minutes. You can record them if you want. You can write them out, just like regular minutes if you want. But if they are in the tape recording, they can be actually kept in a tape recording. One big caveat to not, sending everyone out of the room is that if it's an employee or a board member who is being under discussion, either through the disciplinary action or complaint action or performance review, The employee is allowed, or the board member, to say they would like to have it in open session. That is their choice, not the board's choice. The board may say, we don't want to talk about this in open session, but the employee can say, no, I want it to be in open session. And I've actually seen that happen in one case when a manager was being terminated. They wanted to do an executive session. They didn't want to, have everyone know what was going on. And the manager said, no, I would like to have this in open session, and I want everyone to know what you are saying about me, and I want to be able to respond. So the other part of that is if you're going to be talking about an employee or a board member for any reason under one of those legal reasons, you have to make sure that they know. I was at a board meeting where they decided to do at the last minute a performance evaluation for an employee, and the employee wasn't there. And you could do that. You could decide on the spur of the moment to do a executive session. And I warned them that they were not giving this employee the opportunity to choose an open session. And they just ignored that and went into executive session. Well, that was a violation of public meeting and executive session law, and did open up every single board member who was there, because it's a violation for executive session is about participation, not if you were the chair. You could disagree about it, but if you didn't walk out and leave, you open yourself up to a penalty, and the penalty at this point is $1,000 per occurrence. So this is one of these areas where if you see there's any violation of executive session law, or you think it is, you should get in the minutes that you think that you have a violation, and you should get up and walk out and leave, because you do open yourself up, even if you're just sitting there, even if you disagree, to a $1,000 penalty. And the folks that usually file the complaint are the folks who were not told about the meeting, or felt that the topic went off, the topic of discussion went away from that legal reason. The last thing about executive sessions is you may not reach a final decision in executive session. You can talk about what you're thinking about deciding. Usually this has to do with giving someone a raise or who to hire, something like that. Or if you're going to censor someone. You can talk about what you're going to do, but you can't make a final decision. You can't come out and decide, oh, we talked about it and we decided we're going to give John a pay raise. That's because you can't have secret ballots. And if you say that, we don't know how each person voted. So you have to go into public session and act formally through a motion or resolution on any matter. As I said, the Ethics Commission will investigate any violation, and the civil penalties are given to individual board members. And those penalties right now are $1,000 per occurrence, and they have happened to soil and water conservation districts, and even in the recent past. So it does happen. So there's one more session on executive session. I suggest for any chair that has not did not go to the other one, and actually district managers to attend the one at 6 p.m. Tomorrow night, where I go into executive session in more detail and we talk about some of the nuances of executive session. Public meeting law, again, about minutes. Written minutes have to be provided of all meetings, and written means they have to be kept actually on paper form, because paper is still the only thing that lasts through technology changes. And so you have to actually have, you can type on a computer and print them out, but you actually have to have physical minutes of your meetings kept. I list here, what the contents are. The part I want to point out is actually the result of all votes. When you read the minutes, you have to know how each person voted. So, generally speaking, everyone present, the board members present, are at the top, and then usually most motions, of course, at districts pass unanimously, so we know everyone voted yes. What doesn't work is, and I've seen this, is it says this motion passed on a 5-2 vote, and that's all it says. Well, that does not tell me how each board member voted, and by law, you have to know how each person voted. So therefore, what you need to do is you can say it passed on a 5-2 vote, but so-and-so and so-and-so voted nay. And that's how you could do it, because then you just know that the other people listed as present voted yay. The last part there about a reference to any document discussed at the meeting is part of the official minutes. And so, your financial reports, your staff reports, anything that was brought up at the meeting, a document, those actually become part of your official minutes. Executive session minutes, they usually are kept locked in a cabinet, usually sealed in manila envelopes, whether it's a cassette tape, or not a cassette tape anymore, USB drive, or typed out meeting minutes or handwritten meeting minutes. Those are kept separate than regular minutes. And you have to keep your records forever. Somewhere in your district office, unless you had some major disaster, should be minutes going back to the very beginning of your district. And I know from looking at the SWCD years ago, it was really interesting. And all that dune grass out there outside of Florence and down to Reedsport, well, that was the SWCD SWCD planting that back in the 50s and 60s. Though when I read the minutes, I did notice that they had decided against planting gorse out there, which I guess is a blessing that we decided not to plant gorse. But it's interesting to go back and look at those minutes. Anyone who's requested your minutes in writing have to be sent your minutes. Also, I like to see all your minutes. I do actually read them, so I'd love to see your minutes and see what's going on at each of the districts. All right, we're going to go to public records, unless you have any questions about public meetings.
Just a quick question about committee meetings.
Yes.
Do those have to be announced publicly?
Yes.
Posted in the newspaper?
Well, you send a notice to the newspaper whether they post them or not. But as I said, committees are kind of their own mini boards. So as long as you have a committee meeting and you are going to expect to have a quorum of that committee there, doesn't matter who's on that committee, they act like their own board, and therefore you have to notice the meeting. You have to keep minutes for the meeting. So yes, is that clear?
Yes, it is. Thank you very much.
And I know some districts are very good at announcing, noticing all their committee meetings and keeping minutes, and a lot of them are not. I don't think anyone here from the Upper Willamette, but I'm actually an associate board member at the Upper Willamette right now, and I am in the pain in the butt because I'm always telling them they need to all these new committees, because they just got their tax base. They have like 4 or 5 new committees that meet all the time, and I'm always telling them you've got to public notice your committee meetings, and it's driving the staff crazy. All right, getting to public records law. The public, as I wrote here, every person has a right to inspect any public record of a public body being you, except as especially provided by these exemptions. Unlike the very limited reason why you can go in executive session, the exemptions, which are all conditional exemptions from public record law, is pages and pages long. There are dozens and dozens of them. So what is a public record of a public body? So a public record is anything that is written or an email. It can be text. It could actually be a voicemail. Anything like that is considered a public record. So that includes emails between directors if you're emailing each other, or between the office and office and directors, managers. And the one thing I like to point out, and I always encourage districts to do, is because everything you write about is as public record, the device or the email account you might use is open to discovery in case of a lawsuit. What this means is that if you use your personal email, if you use your personal phone to send text messages, and there is a lawsuit, and the court says, you have to let the lawyer see everything related to this court case, the lawyer gets to get your email and password and peruse all your personal email if you've been using your personal email to find the appropriate public records that might be related to the case. Or they get to go take your phone and look through all your text messages to see what you might have texted. Well, that as you know, leaves you open to everything else that you may have texted every other person or every other email you sent to anyone. So I would like to tell directors, especially because staff usually has, staff phones and staff emails, but directors should have a very specific email related for district work. Very easy if your district can't set it up because you use Gmail or something like that. Set up a separate Gmail account that's just specifically for your district work. If you have a good email client, you can forward those to merge with your other emails, or you just go take a look at that one. But that allows you, if there's any public records disclosure required, you're limiting your exposure to only that email account and not all your emails. So just think about for a moment about if you want a lawyer to look at all your emails or just the emails related to district business. I will saying that, if I scared you a little bit, I'm not aware in my time at ODA of a court case that has gone to that extreme where they've subpoenaed the email accounts of directors, but it could happen. The last point on here, record retention policy, that's important. You have to keep everything, and I'm doing tomorrow actually a longer session about this, but you do have to keep certain kinds of documents for certain periods of time. And it's important that when you no longer have to have them, to get rid of them, because if you do have them, you have to disclose them. So you're holding on to these records, and the public has the ability to make a request to look at your public records. So as long as they're not excluded from disclosure, you have to give them copies or allow them to see the originals. So by law, you have to have a public records request policy that includes a fee structure, because you can recuperate fees. So if you get a request for all the files about such and such project, and it's going to take your staff quite a bit of time to put them together, you can recoup those fees, including photocopying fees, making, digitizing stuff, whatever you would like. So you need to have that policy, and you also need to know about exemptions, because there's certainly different kinds of exemptions. Some personal information, for those working with sage grouse, there's exemptions for sage grouse plans, certain medical records. There's a whole bunch of different ones. Honestly, most of the work that the district does, there are not many exemptions for district work, so most of the stuff will be public. I do have under there, just to let you know, because this has come up recently, is that for elected officials across the board, your address, telephone number, and for whatever reason, your date of birth is not exempt from disclosure. That if someone asks for that information about you as an elected official, you have to give it. There is one exemption if you can demonstrate personal safety, which is actually harder to do than you think. You have to actually put it in writing. You have to say exactly why you feel you're in personal danger. There is a set of criteria, and that actually exemption is for a limited duration, and you actually have to renew it. So just be aware that some of that personal information, just as an elected official, is subject to public record law. Any questions about that? Doing good? All right. The last thing I want to talk about here is ethics. Ethics is another area besides executive session law that will get you in trouble, because there are penalties associated with ethics violation. So who is covered by ethics? Public officials are covered by ethics. Public officials are not just elected officials, but they're also all your employees. Certain volunteers who do regular volunteer work, folks that may come in your office every week to do some filing or other kind of work, not occasional volunteers like volunteers for your plant sale or tree planting or something like that. And agents of the district. Agents of the district are usually contractors who are representing you in some way for a specific purpose. Some districts use contractors to interact with landowners and put together projects on behalf of the district. They could be considered public officials. Also covered are your relatives, and you can see the list of relatives there. And businesses with you're associated are subject to the Code of Ethics. I have a whole thing on ethics. I have some fact sheets on ethics that describe what businesses are. I'm not going to go into detail here because of the time, but those are who is covered under ethics law. In basic ethics law, it says that you can't use your office or your employment at a government entity for financial gain or the avoidance of financial detriment, if it wasn't for the fact that you hold that position. On a very simple level, very simple example is using the office copy machine to make some copies. You can't just go in there and say, you know what, I need a copy of my driver's license. I'm going to just make a copy of it. You can't do that. That is a violation of ethics law, because generally speaking, the public is not allowed to do that too. Now, if you had some policy that says, any member of the public or staff or board member can make copies for 5 cents each, that would not be a violation, because you're allowing anyone to do that at a cost, or you could do it for free. Another one that comes up sometimes is, you have this district vehicle, nice big truck, and you're moving something really big, doesn't fit in your own vehicle, and you're just like, I'm just going to borrow the district truck. It's just down the street, or maybe it's an assigned vehicle and it sits at your house, and you're just going to borrow that truck real quick to move something. Again, the public doesn't get to do that, and therefore that'd be a violation of ethics law. So those are kind of the very simple things, and we're going to talk about some more complicated things getting into ethics law. One of those more complicated things is the one that I've underlined there, is about gifts from sources that have an administrative or legislative interest. So you're not in the legislature, you have no legislative interest. But administrative interest, especially as board members, when you would be voting on, say, contracts, is a big administrative interest. And so if you receive gifts from anyone that you may be like giving contracts to, approving contracts for, or maybe approving grants for, or projects for, that's an administrative interest. An example for this that was real for me was when I was at the SWCD, and this applies to employees as well as board members. We use a very specific excavator contractor a lot. Local person, always available, not very expensive prices, knew what he was doing. So I was able to award contracts up to about $5,000 without the board approval. And I often approved contracts with him for small grants, $2,000, $3,000, $4,000 jobs a lot. So I had an administrative interest between us. And so sometimes we meet for lunch to talk about projects he's working on, upcoming projects, just to hang out a little bit. And he'd want to buy me lunch. Well, that's a gift. And a gift is okay as long as it doesn't add up to more than $50 in a calendar year. And so I just had to be careful that it was just 1 or 2 inexpensive lunches and not a whole bunch of them. So that's fine. But do remember that this also applies to relatives. So as a board member, if maybe you'd be awarding contracts to a particular contractor, this relates not only to you receiving gifts of up to $50 per calendar year, but your spouse or your siblings cannot receive gifts of over $50 per calendar year from this person. So just keep that in mind. It's not just about what you receive, but it's also those definitions of relatives too. There is a caveat to that I did learn about. If you have, before you became a board member, before you became a public official, a long-standing relationship with someone, say your next door neighbor or a relative, you have exchanged gifts, and very nice case of wine every year or something more than $50 per calendar year, and you were doing that for a long time before you became a public official, Generally speaking, you'll probably be okay with that. If suddenly they went from giving you a $10 bottle of wine every year at Christmas to a $100 bottle of wine as soon as you became a board member, that would be a problem. But as long as there's this long customary history of exchanging gifts, then you'll probably be fine. Not a lawyer, but generally speaking, that's my understanding. Any questions about that, about gifts? Okay. Some additional prohibitions. The one the middle one there is about confidential information. In many districts, you might look at farm plans or other kind of information from your competitors. And you can't take that information from your competitors that you learn and use it against them. That would be a violation of ethics law. And then the other part I want to talk about, and we're going to take a little bit of time about this, is conflict of interest and whether it's actual or potential conflict of interest. So I'm going to define what each of these are in a moment, but I'm going to tell you what you have to do before I define them. So if there is a conflict of interest, if you are an employee, you have to notify your supervisor in writing through an email that you have a conflict of interest and just not be part of that decision-making process. And you probably should have a policy in your personnel manual about it. For board members, it's actually divided into two things: potential conflict of interest and actual conflict of interest. You can probably get an idea where those are leading. If you have a potential conflict of interest, you have to announce in the meeting publicly, so it's in the minutes, that you have a potential conflict of interest, but then you can go ahead and have a discussion and partake in the vote. If you have an actual conflict of interest, again, you must make sure to announce it publicly, so it's in the minutes, what the nature of that conflict is, and then you have to refrain from participation in the discussion and make sure not to vote on the issue. Some directors think you have to leave the room. That's not true. You can still be there. You just cannot participate in the discussion. So let's look at what those are. So an actual conflict of interest is actually a little easier. That's when you might have some financial benefit or avoidance of detriment for you or a relative, as defined, or a business which you're associated with. And some examples of this is voting on contract issues that perhaps the contract is being awarded to yourself, which actually happens quite a bit, especially in the districts with limited resources and people who do specific work. Board members sometimes are the people that do the work. And so they're allowed to bid on that, and they're allowed to be awarded contracts, but that would be a conflict of interest that they cannot participate in that discussion or vote on. But also relatives, because again, in especially smaller counties, relatives might be the ones doing services for the district. Another one is there are some districts where there are a board member and a staff person have some kind of relationship, husband and wife in one area, one time, sibling in another one in a past. And so if you are going to discuss raises or disciplinary action, performance evaluations, even probably voting for the budget if that budget has a pay raise in the budget or an increase in benefits in that, that would be a conflict of interest, and therefore that family member or relative would need to go ahead and declare an actual conflict of interest and refrain from the discussion and voting. So those are some examples of actual conflict of interest. A potential conflict of interest is the action or decision might have a benefit or avoidance of detriment or a detriment to someone, but you're not quite sure at that time. One of the example for that is if the board is approving a contract to go out to bid, and one of the board members know they're going to bid on it, or a relative of theirs is going to bid on it, or say the board approves the district to go buy a truck, but one of the board members you're your brother has a car dealership, and you know that they might potentially be the person to sell it. That'd be potential. You're not quite sure that you're going to get a benefit or not, or a relative is, but it's possible. So that would be a potential conflict of interest. A question that I do get asked a lot, and I don't have a definitive answer for it, is what about projects? Because often board members are having projects done on their property, a riparian project, fencing project, weed project, something like that. So you have to think about, are you having a financial gain or avoidance of financial detriment through that project? Most likely, yes. You know, say it's a weed project. Well, if someone is coming out and spraying for you instead of yourself, you're avoiding a financial detriment. If you're getting a grant to put up some riparian fencing that is needed to ensure that you follow the agricultural water quality rules, that is also, you know, avoidance of financial detriment or financial gain, because you're actually getting some infrastructure on your property. So most likely, though there could be cases where you do have a project that may not meet those things, if you do have a project that is being done on your property, then you're going to probably want to make sure that any kind of action the board does around that you do not participate in the discussion, that you declare an actual conflict of interest, or at least a potential conflict of interest. There are some exceptions. On the east side, sometimes there's at least one district that buys pesticides in bulk because it's very hard to get them because of the remoteness of the county and the district. And then the district resells at, you know, a discount because they're not trying to make money to the agricultural community, which includes some of the board members. That is completely fine because they're selling it to all the board members equally. In the past, when there's been some major fires on the east side, some districts have bought grass seed, or, you know, native seed, grass seed for reseeding and distributed it, and also hay for livestock, and distributed that. And that's fine too, because again, that affects everyone in the same class the same way. If you are on the board of a nonprofit or a member of a nonprofit, specifically a 501c3, 4, there's all the different kind of C's, then it's all right for you to say vote to give a grant to that nonprofit that you are actually on the board of, or just a member of. And then the last one there is, well, getting back to that thing where you need 3 or 4 yay votes depending on the size of your board. What if you have a 7-position board? You only have 4 board members at the meeting, and one of them declares an actual conflict of interest. Therefore, as I stated, you only have 3 yay votes, and 3 yay votes, it will not cut it. You need 4. In that case, it is legal for that person with the actual conflict of interest to vote. They're not allowed to participate in the discussion, but they are allowed to vote. My saying is, just because you can doesn't mean you should. If there's any way possible to not have that person vote, they probably shouldn't. Can you get someone on the phone? Can you delay it for another meeting? That would be much better than the optics of someone voting at themselves a $50,000 contract. So yes, if you need that vote, you can get that vote out of that person, but it's not the best public policy. Any questions on ethics at all? All right, we're getting to the end, and I realize that I skipped over one thing that I wanted to talk about public meetings. So I just want to go back and, especially if you're new, it's important to know that through case law, public meetings can actually happen via email or telephone calls. And it doesn't happen, it can be serial phone calls, and it can be serial emails. So you want to make sure that if you have communication via email through your manager or someone at your district admin person sending out notices about meetings, that you don't start hitting reply all or start sending emails to all the other directors. Because as soon as a quorum of directors are sharing emails in any way, having an email discussion, that actually becomes a public meeting. Actually, it was here in Lane County, because I'm here based in Eugene. That was the court case where the county commissioners got in a lot of trouble for that and got fined for sending emails back to each other and talking about the budget and what they were going to put in the budget or not. So make sure that you don't start emailing each other or calling each other. It's all right to call and talk to 1 or 2 board members, but as soon as you hit the quorum, and especially like the chair might start calling some of the board members to get their opinion and talk to, you know, one and then another. Well, if you got a 5-member board and the chair talks to 2 different board members about the same topic and shares what was the information that was shared, you've actually had a serial phone call public meeting that was not properly noticed. So just want to clarify that you just be careful about your emails. Make sure you don't have an email conversation among all the directors, and make sure you don't have phone calls that turn into a serial public meeting. All right. Because we're getting to the very end here, there's, as you may have noticed so far, there is a whole alphabet of soup of acronyms here. So just go over them briefly. These are the ones that you might hear. You might hear SDAO, Special Districts Association of Oregon. That is a group, an association of special districts. Special districts include you, but they also include fire districts, park and rec districts, like I said, cemetery districts, irrigation districts, drainage districts, all those various little districts. And so this group, SDAO, which I think every district at this point is a member of, they provide trainings, insurance, and financial services. Excuse me. And often when I get asked questions, I go to them to get answers, or I send the district to them. They actually have lawyers who can give you legal answers. OACD, the Oregon Association of Conservation Districts, is your district membership organization that represents all the Oregon SWCDs. One of their main jobs that they do is lobby on behalf of you at the legislature and follow bills. It's what they're doing right now, a lot of their time. But they also provide some training services too. Ocean, Oregon Conservation Education Assistance Network. They're a network of mostly employees, and they do capacity building, education, and professional development. The big thing that they do is called Connect, which is an annual conference for both district employees and watershed councils, and also board members. Very great, usually 3 or 4 days long, 100, 200 people coming together from the conservation world, and it's a great thing to do. Network of Oregon Watershed Councils, the NOWC, I've heard it called NOWIC, NOC, different kind of things like that. That is basically the equivalent of OACD for watershed councils. They work closely with Ocean and OACD, and also COLT, the Coalition of Oregon Land Trusts, and the 4 of them have this conservation partnership and do a lot of things together. The last thing you may or may not have heard of before is OWEB. They're the ones with all the money for grants and for a lot of the work in watersheds, and that's the Oregon Watershed Enhancement Board. So those are some of the basic acronyms that you might hear. There are a lot of additional resources and training. As I said, this very much just skimmed the surface of information. You know, I just kind of did the basics about public meeting, public records, and ethics, and I think there's a lot of important information, especially about executive session and ethics. So you have Margan, myself, and Sandy. You can call at any time. Your staff should have our phone numbers. It'll be up here in a minute if you want. You can get it online. We have a website with lots of information that's you can go take a look at, and especially get information about the training and the slides and the recording of all these things. The district guidebook, your office should have 1 or 2 copies. Looks like this. I'm always constantly trying to update it. I'm a little behind right now. There's some stuff that's out of date in here. But especially if you're a chair or a new director, you might want to take a look at this. This goes into detail about all the different operations of the district, from the legal stuff that we just talked about, but also about finances and budgeting, running meetings, partnerships, and stuff like that. So this guidebook is, I think, an excellent resource if you can get your hands on it. There is an electronic copy available on our website too. Those folks that I just listed before, almost we all have email lists where information goes out. Special districts, is a great resource for everyone. And then there's a whole plethora of manuals and guides on, from the Attorney General and everyone like that. So that is my very fast skimming through all the information that's as a new director, it's very overwhelming and there's a lot of stuff. So Brenda asked if, as a director, non-chair, contact the district manager, ask questions as needed. I think it's your prerogative to be able to do that. You should check with, what your board policy is on that, in case there is a board policy. And absent of a board policy, I always say it's kind of a free-for-all. That's why board policies are good. But one of the things that definitely should be in policy is who gives direction to the manager. In that case, if it's not all the board members, usually it's a specific board member, you shouldn't give direction to that manager. I'd also be aware that, managers do get, I hear this all the time, I've got 7 people who are calling me all the time. So just be aware that, there's 7 of you that may want to be contacting that manager, and be aware of their time and be sensitive to that. But there's nothing that says that you can't contact the district manager. And I think especially if you're a new district director, that, having a sit down with your district manager would be an excellent thing to do, and just get to know them, because they're the ones doing the work for the district. Any other questions? You're welcome, Brenda. Well, I hope you enjoyed this. I hope you got something out of this. As I said, this was just skimming the surface. Please feel free to contact me at any time with questions. The recording of this session and all the other sessions I've been doing this week is available on our website. The slides are, the actual recordings are going to be a little bit longer to get on there, but they will be available. And if you would like me to come to your district at some time in the future, virtually for the short term, hopefully in person later term, I'm glad to do any kind of training you'd like, especially any of these topics in more depth. So have a good night, and take care, and maybe I'll see some of you at the executive session tomorrow night or some of the other ones.